We'll then move on to exemptions. And I mentioned earlier 4 exemptions. Section 4 of the Property Practitioners Act permits applications for exemption from certain qualifications or certain provisions of the Act. The education qualification exemptions, as I've advised, go to the Education Department. All other exemptions come under Section 4 to the Exemptions Department. Note that Section 4 exemptions are granted for a maximum of 3 years, and they may not be granted retrospectively. Now, this is different to the trust account exemption, which Thomas told you about, which simply required an affidavit. It doesn't require an E1 form. You send your affidavit to audit, and that will continue for as long as you don't have a trust account, or you are not required to have a trust account in terms of the legislation. And Thomas advised you what has to happen when you need to register a trust account, when that is required, and how that exemption will then be withdrawn. Bear in mind that when you apply to us for an exemption from a specific provision of the Act, you need to justify how long you want it for and why you want it for that length of time. If it's something that can be resolved within a year, and you ask for a 3-year exemption, we might only grant you a 12-month exemption. You use Section 4 exemptions at the ppra.org.za for Section 4 exemptions. Please do not use exemptions at the PPRA. That is specifically for equivalency exemptions, and it goes to the Education Department. It's essential in your form, and that's the E1 form that you use. The E1 form is found in the regulations. There is a copy of it there. We also do have it available if you need it. And it's required that you indicate on the form from which section of the Act you seek exemption. We cannot grant an exemption for the entire Act. We can grant an exemption for specific provisions and on certain bases. And you need to advise us what it is that you require. The process is that you complete the E1 form, you submit that, you submit your motivation as well, and that goes to our exemptions committee. Once you've submitted it online, it goes to the exemptions department, they prepare it, send it to the exemptions committee, and we will issue you with an exemption certificate if your exemption application is approved. It's very important to note on your certificate the terms and conditions of the exemption, as well as how long the duration is. In terms of exemptions, there's also a process by which you can object. If you are aware of an exemption that someone has been granted and you know or you believe and you have evidence to show that that person has obtained that exemption fraudulently or incorrectly, and you can object to that, and that will be considered by the committee, and we are in a position to then withdraw or amend that exemption. Please note also that re-registering estate agents cannot return at their old status unless they have the required education qualifications in terms of the regulations for estate agents. Okay, so that is essential. If you want to come back, you need to have the qualifications that are required in terms of those regulations in order to come back at the status that you were previously. Right, some important notes. New non-estate agent managing agent practitioners will be required to submit an E1 exemption form where they have not completed an internship or a PDE exam. And in that exemption form, you will request exemption from the provisions of Regulation 33. So this means that if you are coming in as a managing agent, a practitioner, whether it's as a director or as an employee, and you have never been an estate agent, and you don't have a PDE exam qualification and an internship that you served at some stage, which is on our books, you simply then submit your E1 exemption and you say, please exempt me from Regulation 33. I'm coming in as a managing agent, and I've not yet been able to do this because they are not yet available. Okay, so that's how you have that. And we have that on record to ensure that you can continue to operate and get an FFC, in spite of the fact that Regulation 33 says you can't operate as a property practitioner without having done an internship and a PDE exam. So that exempts you from those two requirements for the moment. Please be aware of Section 58, which prohibits all property practitioners, whether it's estate agents or any other, from entering any arrangement, whether it's formally or informally, in terms of which your client is encouraged or obliged to use a particular service provider. Please note that this includes a conveyancer. It is absolutely prohibited for any property practitioner to print or to enter in their contract with their client, whether it's the mandate contract, whether it's a sale contract, whether it's an offer to purchase or anything else, to enter what conveyancer they want the client to use. They may also not encourage them to use a specific conveyancer. Remember always to log a query after uploading documents, and if you're tired of hearing that, then hopefully you will remember it. Attorney employees are limited, please note, to activities arising within the attorney's legal practice. The definition in Section 1 is very clear as to the exemptions that apply to attorneys and what attorneys can do, attorney employees also, and what they do within the activities of their attorney's legal practice. And that is what they are employed to do, and that's what they are limited to do. So they cannot simply set up their own little practice or property practitioner's firm under the auspices of the attorney's registration. Please be aware of that. Please also be aware of the managing agent's exemption, which allows managing agents who manage body corporates to operate without a trust account for purposes of those body corporates. So if you have a managing agent who only manages a body corporate, you may be exempt from holding a trust account on the basis that you show us, and you do this by providing the evidence to the audit department, that they are managing a firm, rather they're managing a body corporate, which is registered with CSOS, that the body corporate operates its own account in terms of the body corporate and sectional title legislation, and that in terms of that, their money is kept in their own account and not with you. So that you need to provide to the satisfaction of the audit department the evidence that that is the situation, and they may then exempt you from having to hold a trust account. Thank you very much. I hope that you've been able to follow some of the ins and outs of this process. It's sometimes a little daunting, but I hope that this has assisted in helping you understand how to navigate our portals. Those are some of our following social media contacts, and if you have any issues, you are always welcome to contact us in the registrations department via the call center. Thank you very much.
Thank you, Advocate, for the presentation. We took some questions from the chat. I have one question, Advocate, from Elma. It says, estate agency registered under EAAB previously, now only doing managing agent work. Do we have to register as managing agent again?
Yes, you do. In terms of the Act and regulations, if you are not doing estate agent work anymore, you need to deregister as an estate agent, and you then have to register a new firm as a managing agent. This is because you need to have a managing agent fidelity fund certificate, and you cannot operate as a managing agent under an estate agent fidelity fund certificate. It is not permitted by the Act and regulations. If you want to do both, that's fine. You can keep your estate agent firm open. You can obtain your fidelity fund certificate for your estate agent firm, and you can do the same for your managing agent firm. However, if you don't want to pay for your trust audit for your estate agency, and you don't want to pay for a fidelity fund certificate every year for your estate agency, then you need to deregister it as indicated. and you then will transfer and register your managing agency instead.
Okay, thank you, Advocate. Most of the questions that are on the chat that have email addresses, we're going to respond to all of you after the webinar. For now, let's take hand. The first hand at 1, Josias, please ask your question. Unmute yourself, please. Josias, are you winning? Okay, I can't hear you from my side. Hello? Okay, Josias, we're going to come back to you. I'm looking at the time. We need to move. Cynthia, please ask your question. I'll go back to Josias. Okay, they might be struggling maybe with connectivity. Josias, Cynthia, maybe they can't hear me. If you can hear me on your side, please do a thumbs up. I'm going to go to Israel. Please unmute yourself and ask a question. I'll come back to 1 and 2.
Sorry. Hi, can you hear me now?
Who is speaking now?
Yeah, it's Cynthia. Good day.
Okay, Cynthia, please go.
Okay. This is actually a question that I was going to ask Thomas. We opened up our real estate agency in 2021. We were supposed to give our exemption letter because we have to have a trust account, but it is dormant by not later than the 31st of August. So that was not in time due to the death of my son. And we then sent our application on the 31st of October, 1922. So we have followed up with PPRA for quite some time now. I am busy with the auditors department, but in the meantime, obviously, we have had 2 fines amounting to 50,000. And I realized that we were guilty, apart from the fact that you do have emotional trauma. I'd like to know, where do we apply for at least some reduction in these penalties?
Naledi, is Thomas still
Thank
in
you,
the meeting?
Cynthia. Thomas? Yes, he's still with us, Thomas.
Thank you, Naledi. And thank you, Cynthia, for your question. So on the compliance notice that you must have received, Cynthia, there is an email address there. Unfortunately, there is no reduction of fine that will be considered. What can be considered will be a payment arrangement. So they can spread the fine over 6 months so that you can pay in installments. But please use the email address that is in the compliance notice that you received. Thank you.
Okay,
Thank you, Thomas. Let's try Josias again so we don't disadvantage him. We try you one last time, Josias. Please ask your question. And you will notice most questions will be audit because we didn't finish with Thomas before Deborah. So registrations questions are still coming. Josias, please go. He's not winning. We tried Josias. Cynthia, you asked your question. Israel, please come through.
Yes,
hello, Israel. Yeah?
Yes, thank you. Yes, thank you, Joshua. I appreciate.
Hello. Josias,
can
you
Israel
speak now? Israel, please give me a minute. Sorry about that. I think Josias' connection is let's give her a chance. Josias, please come quickly. Please, let's ask your question straight to the point. Josias? Okay, we're not winning, Josias. Please ask your question on the chat. Put an email address. We're going to help you. Send us your question on the chat. Israel, please come through. Sorry about that.
Thank you very much for the opportunity. The threshold regarding regarding not having to submit audit report is clear under 2.5 or less. I'm talking mil now. Okay, the question I have, it's more to do with the trust account. We still have a trust account active. However, when I'm saying active, it's open. But we never kept throughout the life of the agency. We never kept any fund. except to pay the admin fee, to keep the account open with the bank. So now, am I right in saying the process to close first before winding up, we close the account first, then the accountant will do the winding up of the account? Is it correct?
Thomas?
Okay. Thank you, Israel. Yes, I heard your question, Israel. Thank you. So you need to close the trust account, and you need to have your auditor audit the closure and submit a winding up audit report. So it is your auditor, not your accountant, who should do the winding up audit.
Oh yeah, the auditor. Yes, that's right.
Yes,
that's right. Yes. Okay. Then the last question, Thomas, it's regarding the audit account itself. Am I right in saying, though, I mean, because of the turnover, which is under 2.5 million, that we don't have to submit the audit report. However, because the trust account is still active, that we are still under an obligation to submit an audit report just for the trust account. Is it correct?
Yes, Israel, that's correct. So the submission of an audit report to us is not dependent on your revenue threshold. It's dependent on whether you have got a trust account exemption letter or not. So if you do not have a trust account exemption letter, you still need to submit an audit report, irrespective of your revenue.
Okay, understand. Okay, thank you. It's clear.
Thank you, Israel. Alan, please ask your question. Sorry, Israel, do you have another question? I wanted to give others to ask.
Question, not for Thomas, not for Thomas, for Deborah.
Okay.
She had mentioned a presentation of Section 58 that says we are not, as practitioners, we are not allowed to encourage the use of a specific service provider, for example, a conveyancer. This is a practical example. I mean, there are cases where the seller has got no relationship with any legal firm, and for that reason, the seller then says, look, do you have any relationship with any conveyancing firm, or do you know of any conveyancing firm that could assist in terms of the transfer of the property? What do I do in that case? Because I mean, naturally, I mean, many practitioners do have a relationship, one or the other, or know of a conveyancing firm. So if I'm not supposed to pursue, I'm not pursuing, but I mean the seller is asking, and I'm in a position to say yes. I mean, what are the parameters here in relation to saying to the seller, yes, I know of a specific firm that could be used? Because naturally, I think that there shouldn't be a problem with that.
Well, thank you for the question. Yes, you're quite right. If you look at the regulation or the section that I referred to, it prohibits you from entering into an arrangement with the conveyancer in terms of which you are obliged or encouraged to get your consumer, by way of such obligation or encouragement, to use that particular service provider. So in your instance, you don't have any special relationships or arrangements which require you to advise your consumer to use them or encourage your consumer to use them. Where your consumer asks you if you have or know of anyone, there is nothing to stop you saying, yes, here is a list of possible ones that I've used, that I've had no difficulty with, or here is one that I know of, which you might like to try, but you may not either force them to use that firm or encourage them to use that firm. So encourage would be saying, well, yeah, this one here, there's one that I've used all the time and I never use anybody else. This guy's fantastic. I encourage you to use that person. I wouldn't use anybody else. That's what you're not allowed to do. Okay? I hope that's clearer.
Okay. Thank you.
Thank you.
Thank you, Israel. I'm thinking 3 questions. It might be a lot because I see there's 20 people who's raising their hands. There's chats more than 20. I'm looking at the time. I don't want to keep you here until you're exhausted. Let's allow Alan. Let's go through. Alan, please ask your question.
Thank you very much. My question is for Advocate Vale. 2 questions. The first one, in terms of the 12 categories of property practitioners under the PPA, point number 7 refers to business brokers, including sales of franchises. would that then include all the big brands that are selling their franchises to prospective principals out there? That's question one. And question two is similar to the previous question. I've seen a number of contracts out there that has got a clause in the contract that is not a compulsory clause, but it's certainly an encouragement to use, for instance, a certain mortgage originating firm. Would that be a contravention of the Act?
Okay, thank you for the questions. First of all, the answer to your first one is yes, it does include franchises for the sale of property, particularly businesses, etc. And that's by way of the Minister's proclamation in the regulations, which included franchises, etc. You'll find that most of your big franchise salespeople are actually registered as estate agents or property practitioners as well. So they do have to register, and depending on what industry and if they operate in multiple industries, they would need to have multiple FFCs. So that's I think answers the first one. The second one, you may not be aware, but we did have an exemption which was applied for by some of the organizations representing estate agents, as well as the Mortgage Bond Origination Association, which applied in terms of Section 4 for an exemption from the provisions of Section 58. And that was granted on certain conditions. And what it basically meant is that practitioners, for a period of 3 years, as well as bond originators, are permitted to encourage a client to use a bond originator. And that exemption was granted on the basis that when we looked at the applications, they actually came and convinced us with extrinsic evidence and with some audited figures that it was in the interests of consumers, which is one of the requirements that we have to comply with, that people be allowed to use the names of bond originators to assist their clients in obtaining bonds or mortgages. And we went through the process with them as to what their members do, how the process goes through, how it advantages particularly disadvantaged consumers in obtaining bonds, etc., and what the process is. And on condition that the mortgage originator that is recommended complies with those exemption requirements, a property practitioner is permitted to recommend them. And so there is an exemption granted for that to all property practitioners. So that's why they can do it.
Thank you very much. Just to clarify on the first part, so in terms of a franchise company, if their sole business is selling franchises to other property practitioners, they're not dealing with the public in any property transactions. They still must hold an FFC.
That's correct.
Thank you. Thank you.
Okay, thank you so much. Let's go to Keira Maladzo.
Opportunity. I just wanted to get clarity. Sorry if I'm maybe asking a question that was asked, but it was not clear to me. In terms of the threshold for revenue, is this implying to the trust account only or the business current account?
Thank you, Thomas.
Okay, thank you for the question. So the revenue threshold only applies to the annual financial statements. In other words, it only applies to the business accounting records. It does not apply to the trust account.
Business, okay, all right.
Yes.
Thanks a lot.
Thank you.
Right.
Thank you, ma'am. Let's go to BM.
Hi, thank you once more. My question is to the advocate. Regarding the FFCs, we've received some training saying that the numbers of the FFCs, they sort of like specify who belongs to which category. But I believe that it is actually a bit of jargon. Why should it, can it not be clearer to say that this FFC for the bond originator is strictly for bond origination reasons only? Because if an attorney receives an FFC and a deal, for instance, a transaction, they simply take that. What are there any provisions? What their restrictions? What else can they do? Because now we see a lot of bond originators suddenly becoming agents just because they've got FFCs. Can it not be clearer to say you're not a property practitioner? Because now there's a thin line. Now everyone has FFCs, and the FFC is not even written. It's only a number, which one needs to understand what each letter means and represents and everything like that. And it's increasing almost like weekly. I hear new bond originators saying they're now agents. Thank you.
Okay, thank you. First of all, that's incorrect. If you look at your Fidelity Fund certificate, at the bottom, it specifically says which industry the Fidelity Fund certificate is issued for. It doesn't just have the number is at the top. And the way the number is configured is for our benefit. That tells us and tells our system what industry this FFC belongs to. But for people out there, they will see it very clearly on your Fidelity Fund certificate, and it specifies, and it's required to specify it in terms of the regulations, what industry that FFC applies to, and it applies to no other industry.
Okay, are you happy, ma'am, with the answer? Let's go to Carl.
Hi, my questions are for Deborah. Deborah, thanks so much for your time so far. I've got a couple of questions. My first one is got to do with registration with the FIC for managing agents. Is it my understanding that only estate agents are regarded as accountable institutions? Why do managing agents need to register with the FIC and get an AI number for registration purposes?
Okay, the reason for that is that the FIC legislation currently refers to estate agents because we only regulated estate agents. Currently, the FIC approach is that they are in the process of changing that, and the amendments will be coming through. And when that happens, we will have to have FIC registration for everybody. So it's on that basis that we will have to report to them as well.
So you're saying it's going to be inevitable anyway?
Yeah, basically
Okay.
that's what we've been advised.
All right. For the registration process, I understand that the director has to first register on the MyPPRA online portal.
Yes.
Is it necessary for only one director to register the firm, or does every single director need to carry out that same exercise by registering on the PPRA online portal?
No, your one director can register the firm, but he will require all the information of the other directors, and the other director will have to register himself as a director individually under that firm.
Okay, cool. And then a resolution. You mentioned previously that we need a resolution to be done. That resolution must obviously include the authorization by the company to register the firm with PPRA. That's
correct, yes.
All right.
And also bear in mind that might be needed where if you have a director who is a non-executive director, and therefore does not have to have a Fidelity Fund certificate or can apply for an exemption from a Fidelity Fund certificate, then you would need on your resolution to specify that director is a non-executive director and that he doesn't have any day-to-day control over any estate, any property practitioners or any property practitioner business.
Okay.
To include that. Okay.
Okay. And then with the registration of the firm, you've said that we have to register each one of our directors, for example, executive directors.
Yes.
Do I submit those applications together with the firm registration application form?
You do it separately under your individual portal, your individual property practitioner portal.
Cool, because that comes back to my... Yes.
Yeah. Sorry, the application forms for each of the directors will go in there, but your application form, when you do your firm, yes, now I understand what you're saying now. Yes, when you register your firm, then you're going to register the application form. You're going to submit the application form for the firm, and you're going to submit the application forms for the directors.
Oh, okay, right, great. Okay. with those individual application forms for the directors,
Yes.
do I submit the E1 exemption form for exemption from Regulation 33 with the individual director registration forms, or do I do that separately somewhere else?
No, you do it with the registration forms.
Okay.
And then if they need to register separately, they shouldn't if you've registered them already with the firm. But yeah, you could just attach them to that, and that will be sufficient because they'll come through and they'll be on our record system anyway. So that's fine.
Okay. And there's my last question. Thanks so much for your time so far. Is that once all the documents are submitted, do we only pay thereafter?
You can pay before if you wish, if you know how much is going to be required, or otherwise you can submit them and we will send you the amount. But if you do pay beforehand, simply attach a copy of your proof of payment or pay using on the website itself, and then it will be allocated automatically.
So I've spoken to one of the consultants at the call center. They said that the application fee is 2.9 or 9.5 or something like that. Is that an all-inclusive fee for the registration of the firm as well as the directors?
It's for the registration of the directors under the firm, but each director would have to pay for their own registration to be able to get their own Fidelity Fund certificate.
All right,
so the firm doesn't pay, but the directors pay.
All right. So it'll be separate amounts for the firm and then for each director. All right.
Yeah, there's nothing for the firm itself. You don't have to pay that, but we won't issue the firm's FFC until your director is registered and has his own FFC as well.
Perfect. Thank you very much, advocates.
Pleasure.
Thank you, Carl. Okay, Carl, if you get stuck, please email Advocate Vile anytime. She will assist you going forward. Let's go to Morogwane. Please ask your questions. Morogwane, please unmute yourself.
Hello.
Hi, ma'am. Please ask your question.
Yes. My question is about the trust exemption and also the compliance. On the presentation, I heard that you must close your trust account. So I was wondering if I close my trust account and then the tenants have to pay the amount of the rental to the trust account. On the PPRA side, how long do they take to update the details so that now I can give the tenants a new account number to pay the rental amount? And also the other question that I have 3 questions. The other question, they also said we must give back the amount to the clients. In my case, the clients are the tenants, so the money that I have is their deposit amount. So can I transfer the money to the owner as I can't give back the tenant their money since they are still staying there? And I think it will be difficult for them to return the money on the new trust account number. And the other one that I want to find out is the affidavit. Is the affidavit a PPRA affidavit or is it a normal one that we are used to, the one from the police station? Thank you.
Thank you, ma'am. Thomas, please come through.
Okay, thank you, Morokwane, for your question. If you are using a trust account, like you say, tenants pay money to the trust account, then you shouldn't apply for a trust account exemption because it seems you handle trust monies. So you need to keep your trust account open, and then you do not need to apply for a trust account exemption. Then for the affidavit, the template and the format is included in Regulation 2 of the Property Practitioners Regulations. So you will be able to see the template and the wording of the affidavit. Thank you.
Okay, thank you so much. Let's go to Mozamil. Hope I'm pronouncing it right, Mozamil. If you can unmute yourself. Hello, Muza.
Yes, can you hear me?
Yes.
Okay, so I got a couple of questions. Number one is on the FFC certificate, will it state that whether a person is an estate agent or a managing agent, the FFC is registered to? And number two is if a managing agent, his FFC is registered under company A, can he practice under company B and company A at the same time with one FFC?
Thank you, Advocate.
Thank you for your question. Okay, for the last one first, if you are an estate agent and you work for an estate agency and you are an employee, you cannot operate under another estate agency firm. You have to operate under the one that you are employed with and no other. We will not allow you to register under another firm. If, however, you are a principal, you can be a principal of one firm and you can also be employed by one other firm. You can be a principal of as many firms as you wish, as long as you comply with all the requirements of a principal in relation to those firms. As far as the website is concerned, we currently have development going on our website relating to what consumers will see when they go in. We do have a problem at the moment in that it's showing a lot of people as invalid who are in fact valid, and so we are working on that. Got our developers there. Currently, you cannot use it because it will not give you correct information, but we are in the process of changing that, and it will then be in a position to show you what FFC for what industry they have, an FFC has been issued, and who has a valid one.
Okay, because Deborah, I did email you about this here because I got the person's FFC certificate. He did send it through to us, and it states a state agent, a state agency under industry, but he's practicing as a managing agent, and this has been going on before he can even have a registered business. And he applied for exemption of his business when he's not even the principal of the business. There is actually charges under Section 48, Section 47, and Section 56 that was opened, but this guy was still given an FFC. How is that possible? Because of the fact that this guy is given an FFC, yet he was charged previously, and he's still practicing and still committing incorrect behavior, and he's bringing down the property practitioners' names. And this is going on for almost 13 body corporates, and people are getting actually threatened by him. And I mean, seriously, we actually had to get e-news involved in this year, and we had to lay criminal charges. And I've been emailing PPRA executives, advocates. Jolene Wiseman's name was used by this property practitioner in emails stating, can you ask them, he's fully registered. When we phoned PPRA, we got official documentation. We paid for an affidavit from PPRA, but this guy is still blatantly, he doesn't give a damn about bylaws, about PPRA regulations, and he is practicing openly. And I have submitted evidence to PPRA, advocates, everything. At adjudication, he never even come up. The adjudicator actually tells me that he's the principal. I said, adjudicator, please hold on. This guy is not the principal. Here's the CIPC report. Now, was a CIPC checked when this guy actually applied? Because he applied for exemption for the company he's not even the owner of. Now, that has become such a big issue in Tungat that we are having an enormous issue in this year. I'm actually going ahead with an article in the newspapers about this year because I have emailed you, Deborah, today about this issue. If you can respond to my email, it would be most appreciated, because we have been actually, you got old people that have been involved in this. You got people that are actually are bedridden, people that are disabled, and they may scrape in to pay that levy statement, and this guy is taking the money when he has no rights to actually issue that there. And when we're asking for that there from y'all for assistance, we're getting nowhere with PPRA for assistance. The guy was actually given, even though there was charges, He was still given an FFC to practice as an estate agent. We got the certificate. His certificate clearly states industry estate agent, but he's practicing as a managing agent.
Okay, well, I'm afraid I'm very confused by everything that you've said, because there are a number of things that don't make any sense to me. So I'm not going to deal with all of it now. But I just want to say the following. First of all, if he has a Fidelity Fund certificate, it doesn't allow him, as an estate agent, it doesn't allow him to operate as a managing agent. So immediately he's in contravention of the Act for that.
Thank you. Can I email you immediately about that?
Just a minute, please. Can I just finish? As far as the adjudication is concerned, you indicated that he did appear before an adjudicator. That's part of our legal department, so I will not have any knowledge of what happened there. But that we can have a look at, and we can see exactly what the situation is there. The other thing you need to remember is that it doesn't help to email anybody here with charges or with complaints. There is a specific provision as to how you go about lodging a complaint, and that you do on our website using the log a complaint button. And that goes through to the legal department, and the legal department assigns somebody to investigate it. And if necessary, they will get the inspections department involved to go and do an inspection. So that's the only place where you can get somebody to investigate the matter, because it's the legal department that does it. So that's who, and the legal manager is Deli Nkambule. Have you emailed her?
I got Advocate Kwadi that's dealing with this matter. There is a PPRA case number that was actually logged with the legal department. And I've actually emailed Advocate Kwadi again this week to advise him this is what his FFC that he supplied us, and he's still practicing under the company B. What can be done? Advocate Kwadi advised me only is that the company B is being charged, but what is going on after that? Because we're saying is that we need him removed immediately so that no other people loses out money.
Yeah, no, the problem is you need to be aware of the fact that there are processes. The fact that someone is being charged doesn't make them guilty. In this country, you are not guilty until you are proved guilty in a court of law or in a suitable forum. So what has to happen is his charges have to go. He has to go before the adjudicator, and they have to charge him, and he has to be convicted. Then they can withdraw his Fidelity Fund certificate. In this instance, he doesn't even have a Fidelity Fund certificate, so he's not operating legally in the managing agent space anyway. So what we need to do is we need to get the details, have legal investigate it, and see whether they need to try and bring a High Court application or go and do an investigation on site. But the two people you need to escalate it to, I can give you if you've emailed me. What is your name? Let me then find the email.
Advocate Vile. Okay, Advocate Vile, it's fine. I think he must email us and will assist. We'll take the query to Kwadi and he will give you the status. And I heard that he mentioned issues of bylaws. We are having a webinar next week on the 30th. We're going to present the code of conducts and bylaws. Please join it. And regarding, Advocate is right, there's processes of adjudication process, because today's webinar, we're focusing on licensing and registrations. Let's not disadvantage other people who are raising their hands, because, we've been here. I also need to release the speakers. They have other meetings so that by 4:12 we are done. Sir, can I ask you that we email you? Let's take it offline. Let's assist you because there's a number of queries. Advocate, let me take another question perhaps. Marilyn, please come through.
Hi, Advocate. Thank you for your time.
Hi.
No, I think I spoke earlier. You heard mine that I have been struggling. I had 4 agencies and I'm trying to deregister 2 since 2019. Now I've done the wound up reports. I've sent the closing letters for the bank. I've sent the emails and I've sent it to registrations and to audit and to compliance notices at the PPRA and to Dipu.Langa at the PPRA, but I'm not getting any joy, and it's been years. I struggle every year. Every year they send me a letter. The last 2 years now for letter of demands, and then I send them all the documentation again, but I'm not getting any joy. I don't know who else.
I think the easiest is that you send it all to me. Do you have my email address?
I will share with her. I will share on the chat the email address for Advocate Vile and for Thomas. Any queries for that, let's send to them. The last question we're going to take is going to be from Christopher. We're not taking any hands after Christopher. Marilyn, we're going to help you. I'm going to give you email address. Let's move to Nuwan. Please ask your question.
Morning.
Yes, sir. Please ask.
Can you hear me?
Yes.
No, okay, right. I think I am totally confused. I'm new in this field, and I was actually want to know more about the rights I am supposed to have inside the property, because I've been implicated as a stakeholder for the past 10 or 15 years, so as from 2013, and I never received any license. Everything is new to me here, whereby I've written my message right now asking to know about my rights, about lease agreement of this stakeholder that I've been implicated into. I've only have documents from the Land Commission saying that I am a stakeholder. And also I was engaged in a stakeholder meeting with the current holder of the property. In other ways, I will say I will be waiting for something like a transfer letter from the company to the claimant, as I am a claimant and an individual claimant. So I'm totally confused, and I wish the PPRA can help me out here.
Okay, so we didn't quite get what you were saying. You're confused about because I heard something about you're a claimant.
Yes, I am an individual claimant, and I have also been implicated as stakeholder for the past 20 years. I mean, from 2013 until now. I never received any dividends. I was never called to any or invited to any stakeholders meeting.
Okay. No, I think that one is for me. Give me your email address. I will include you on my database. When we're sending out communication to our social media, we are working with our marketing department. We'll add you on the list. They bulk email all property practitioners that we have on the system that are valid, that have a valid FFCs. So we are on social media. We are on our website. You can find the information. Our marketing department, they share the information. So, but I'll help you drop your email address. I'll give you more info on stakeholder. We are going to connect with you. You will not miss anything from now. Thank you, sir.
No, thank you very much. Thank you.
Let's go to Zola.
Me?
Yes, we can.
Okay, thank you for the opportunity. The question that I want to ask is relating to this issue of the trust account. So I have been exempt to not to have a trust account. So successfully everything, I've got the letter. Now I am interested to do a management again, because there is a lot of demand from the client asking me that. Then I approach PayProp, which PayProp says they can open a trust account on behalf of my company, so that I can do a management. So just wanted to check that if it is online with the requirement that now I can have a management as well in my company, and the trust account will be opened by a PayProp, and they do the audit report as well. And then the other question was, I'm not sure if someone has already asked that question because I'm driving. So the other question was on this issue of registering as a management agent, because I'm already a principal, having a company as well, and having agent, which we are interested to do the management as well. Thank you. I'm not sure if you're clear about my question.
We are clear. Mr. Makupo?
Okay, thank you, Zola, for your question. So if I understood you correctly, you already have a trust account exemption letter, but it seems it was not granted on the basis that you are using a payment processing agent. So what you need to do is, after
No.
you've approached the payment processing agent.
No, it was successful. I've been exempt already. I don't have an existing trust account open by my company. So what I'm saying, I want to do a management, rental management. So according to PayPro, the company that assists companies with the management, so they do open accounts on behalf of the companies on ABSA. And then in those trust accounts which they open, which they themselves manage that trust account, PayPro, then they will then at a time and give you an audit report as well. So I just wanted to get a clarity, how does that work, that arrangement with the PPRA, where there is PayPro, who then opens accounts on behalf of the agencies so that they can run and manage their management rentals, to get a point. So that's what I'm asking for. I need a clarity there. I don't want to have an open a trust account again, like as my company, but I do want to do a management through this company, PayPro, if you know PayPro.
Okay, Zola, yes, I got your question the first time. All I'm saying is the exemption letter that you have will not work if you want to use PayPro. You need a new exemption letter that says that you are now using a payment processing agent. So once you've approached PayPro, they're going to give you a letter to say they have taken on the mandate to manage your trust account. You need to send that letter to us so that we can give you a correct exemption letter, which clearly states that you are using the services of a payment processing agent. So approach them first. They will give you a letter to say they've accepted the mandate, and email us that letter. Then we can give you a new exemption letter.
All right. So that new exemption letter is not going to be pushing me again to open another trust account as like the one that I've closed.
No, it won't. You still have to use the PayPro one, and PayPro will submit the audit report on your behalf.
Wow. Okay. Now I'm happy then.
Okay, sir. Thank you, sir. We said Christopher is the last hand we are taking. I see, Gracias, you raised your hand now. We do apologize. Send your question on the chat with an email. Let's move to Pumzile. Please ask your question.
Thank you so much. Good morning, everyone. Yes. I'm not sure whether I'm audible.
We can hear you.
Yes, because I'm driving. I've been waiting at the office for so long. A quick question. I think my question is directed to Thomas. You know, I find this whole exercise of exempting people, you know, quite frustrating. Let me tell you why. Number one, agents, for example, the reason there was this clause, this in the act, let me just qualify that. It was because of the frustration the agents were experiencing with auditors. Based on a number of reasons, some auditors did not even want to audit estate agents, you know. Eventually one would get an auditor, but still there would be issues. Case at point now, in my situation, I submitted everything except for the letter, the winding up letter of the trust by the auditor. And I've been fighting with him for almost 2 years. Now I'm fined 52,000. And now here comes Thomas to say, look, we are policing you. We are going to fine you. We're not going to empathize with you. We're not going to sympathize with you. You must pay or make an arrangement. Is that the type of regulator we're looking for? I doubt very much. Let me go further to say, when this act was promulgated, the sole purpose was not to oppress people, but was to assist. But seemingly now, I mean, things are really becoming, you know, so tedious for estate agents to operate. And coming to the issue again of the auditors, I want to propose to the regulator that, you know, they must have a pool. They must have a pool of auditors. That estate agents, not for free, but at a fee, because currently we have trust accounts that or we had trust accounts, because we closed the trust accounts, but we are still being fined. And we submitted all evidence to the regulator, except for the letter that is supposed to be submitted by this auditor. And the auditor, you know, is sticking to his guns that now he's not submitting anything based on attitude I want to suspect. Now, I must be the victim. Initially, the fine was 26, now it's 52. I mean, how on earth can you find an agent when he has done at the word go from the onset, submitted what was due to the regulator? Now to say no, you can't listen to the person must just pay. I feel that is too insensitive. So the regulator must seriously consider of having a pool of auditors which will be representative of the demographics of this country. And then they also, much as it's a free market system, but we cannot be charged, you know, ridiculous amounts just for winding up a trust account which has been inactive. So please, I want to appeal to you guys, try to empathize with the practitioners and sympathize with our situation. Thank you so much.
Thank you, sir. Let's check Mr. Makupo if he's still in the meeting.
Yes, Naledi.
Okay.
No, thank you, Pumsula. I think your comments are noted. And the requirement for a winding up audit is actually in the regulation itself. So if you read regulation 2, it specifically says one of the conditions for granting the trust account exemption is you need to have a winding up audit done on the previous trust account. So it's part of the regulation. So we're just enforcing that part of the regulation which requires us to have a winding up audit done before we grant a trust account exemption letter. Thank you.
Sorry, if he's answering my question. The point is a third party is supposed to do the job. The agent has done what was supposed to be done. Now, I mean, what is supposed to be the solution in this instance? When another person is blackmailing the agent.
Okay, so I think
I need a response to that, yes.
We noted. Thomas, do you want to take a bite again, maybe? Or do you like maybe a virtual meeting or a telephone call with Thomas to discuss it, or you want him to answer you now in the meeting? What would you like?
No, he can send me an email. I've written so many emails to the CEO as well. I mean, even I think my emails are with quite a number of people, especially managers in that institution. I think Thomas has got my email. My name is Pumzile Makosana. He will know me.
Okay, so Thomas, we'll look at that email, so maybe we prioritize and see how we can find solutions to that, because, you know, some of these webinars, it's so that we can look at the gaps and come back to the drawing board and see how we can assist going forward. So we note that and we take it very seriously on that. Let's go to Yulia. Please ask your question.
Hi, everyone. Thank you very much. I will be very quick. Perhaps I missed some information. I just want to understand. We're quite a new company. We started last year. We do not operate trust account. The account of Body Corporate opened into the name of the scheme. So my question is, do we still need a fidelity cover, or do we just register with PPRA? And yes, we have received exemption certificate valid until 30th June 2024.
Okay, exemptions, because I do know Deborah's also needs exemptions, but you're asking related to your audit. You got us exemptions for trust account. You were exempted for trust account or
no,
section
I don't
4,
have. We don't operate trust account, and this is what I've been trying to communicate to PPRA over and over. We don't have trust account. We never had one. We are a startup company. We started last year. Trust account was never in a picture.
Okay, so what were you exempted for?
That's a good question. I also want to understand what are they exempted for?
Okay, Naledi.
Okay.
So
I
the
hear you.
exemption we
Yes,
received.
advocate.
I'm not quite clear because you cannot not have a trust account if you're a property practitioner unless you have been exempted. The Act requires you to have a trust account. So I'm not quite understanding.
The account of body corporate opened into the name of the scheme.
So the trust, you're saying you've been exempted, you got certificate expiring when? When did you get it? Who emailed you?
It was received on 31st of January 2024. So it says the exemption is granted for the applicant until 30th June 2024. Exemption is granted from section 47 and 48. The PPRA is not yet able to register non-estate agent industries, and interim exemptions have been issued.
It's not exemption. Sorry, ma'am. It's not exemptions for trust account. Which exemptions did you apply for?
Nothing to do with the trust account.
Exemption extension for graph properties as a managing agent.
Trade, yes. So what is your question, ma'am?
My question is, I'm not sure where are we now? Do we register with PPRA? Do we need fidelity fund certificate because we do not operate trust account? So I'm not sure. What do we need to do?
Yeah, you need to register.
Please let me come in, Naledi.
Okay.
First of all, if you operate as a property practitioner of any kind, which includes a managing agent or an estate agent, you are not allowed to operate unless you have a fidelity fund certificate. If you operate illegally, it's a criminal offence, and you have to have a fidelity fund certificate for the industry in which you operate. If you are registering as a property practitioner, you have to register as a property practitioner in the industry that you operate in, and you have to have a trust account unless you are exempted from it. Now, the exemption that you got was an exemption in January before we started registering managing agents. At that stage, the system was being developed, and all managing agents, as well as the other 10 categories, could not register. And in order to allow you to operate legally, we specifically indicated that you could apply for an exemption from holding a fidelity fund certificate, which would allow you to operate without a fidelity fund certificate legally until such time as we are able to register you. We are now registering managing agents, and we've put that up on the website. Your exemption will continue to be valid until, it depends what it says. If it says until such time as we are registering managing agents, then it will have, its validity will have fallen away now. If it doesn't say that and it gives you a date in June when it's valid until, then you will remain valid using that exemption until June, when you will have to register your managing agency. Otherwise, you will be operating unlawfully.
Okay, understood. So we still need to register with PPRA, but why do I need fidelity fund certificate? We don't operate trust account.
You don't. You have to have a fidelity fund certificate because the law says so. You operate in a regulated environment. And the law specifies under the Property Practitioners Act that if you operate in the property industry, you are regulated by us and you have to have a fidelity fund certificate. Irrespective of whether you operate a trust account, you also have to have a trust account unless you're exempted from it. So it doesn't matter whether you operate with a trust account or not. The Act makes provision for an exemption from it in certain circumstances. But you cannot operate at all unless you have a fidelity fund certificate.
Okay, understood. So that's what I've been actually trying to understand this whole time. But yeah, getting feedback from PPRA via email is like talking to, yeah, anyway. But thank you so much. Understood. Then we need to proceed with the registration and we still need to apply for fidelity fund certificate. Okay, got it. Thank you very much.
Thank you, ma'am. The frustrations with people who are not getting responses, emails internally, please email us. My email address, you have it, then I can assist by emailing that department so that you get responses. We apologize for that.
Thank you, ma'am. Would you mind to post it on the chat? I may have missed your email address. Thank you so much.
I'll put it on the chat.
Great.
SR, I see username says SR. Please ask your question. Okay, SR, I'm going to come back to you. I'm looking, okay, you're winning. Please ask your question.
Okay, I just want to find out, we are managing agents and we requested exemption. I'm not sure for which now, but will we need to obtain a fidelity fund certificate exemption as well as a trust account exemption if the schemes have their own, the bank accounts are opened in the body corporate's name? Hello?
Hi, ma'am, we can hear you. Advocate, can you assist? I don't know, I think it's the
Sorry,
issue of connection. Okay.
Sorry, Naledi, I had some connectivity issues that you disappeared for a moment. I didn't hear the full question. I only heard bits of it, so I'm sorry. Could you repeat it?
Yes. Okay. So all of the body corporates that we are managing, they have their own bank accounts with the savings and all of that. We don't have a trust account, but we wanted to know, will we need to apply for exemption for a fidelity certificate as well as the trust account?
No, you can't apply for an exemption from a fidelity fund certificate because you're operating as a managing agent and you fall under the Act, so you have to have a fidelity fund certificate. The only thing that you can be exempted from is
we need to have a trust account.
Well, if you're a property practitioner, you have to have a trust account unless you are exempted from it. Okay? So your exemption from the trust account has to be done by way of submission of the required documentation to the audit department. And if you're only managing body corporates, then you can apply for an exemption on the basis that your body corporates have their own account that they operate, which keeps all their funds.
My mic was off, my audio was off.
Please mute yourself.
And that was
and
that is in terms of, sorry, I was just interrupted. And that was in terms of the CSOS regulations, which and the sectional title regulations, which say specifically that you don't need to that those body corporates can register in terms of the particular section. I think it's section 21. But in terms of that, you then send proof of that to audit department, and you say to them, okay, this is my body corporate that I am managing, and here's proof of their account under the managing legislation, and then they can give you that exemption from the trust account.
Okay, thank you. And then Thomas mentioned that there's a letter, an example of a letter that the trustees need to sign in order for us to inform you guys that they are that we are not running a trust account on their behalf. I just want to find out where I can find that.
Okay, so if you go on the PPRA website, you will see the auditor's portal. Then if you click on the auditor's portal, one of the documents that is there, there is a revised guideline on the accounting requirements. If you click there, you will see a document that has got all the annexures and templates.
Okay, thank you so much, Thomas. I appreciate it.
Thank you.
Okay, thank you. And also the presentations that Thomas gave, they do indicate all of those steps. So let's go to Eddie. Eddie, please ask your question. Please unmute yourself and ask your question so that we can finish with Christoph. Yes, sir.
My question is, if there is a developer who develops and sells their own properties, and they have their bond originator as a service, and also they've got their own conveyancer, buyers still have an option to use other service provider other than the developer? That's my question.
Okay, so just to clarify, you want to your question is whether you need to have an FFC or whether you can use other conveyances.
No, my question is, in order to avoid violating section 58 of the Act, if let's say a developer develops his own properties and sell them, and that very developer is also a bond originator, and they have their own conveyancer for conveyancing services, can they tie the buyers to use only the bond origination of the developer and also the conveyancer? Thank you.
Yeah, I think we'll have to look at that business model, Naledi. Just let's take an email address so that I can check that I understand it correctly and I can get some more information about the business model, and then we'll respond.
Okay, it's fine. Can you please send me an email address and then we will share, but also conveyancers, because we don't regulate them. I think it's quite right that we will check. Please send me an email. Let's go to Eddie. No, Eddie, you did ask it. So Cynthia.
Yes. Thank you.
Okay, let's see, Cynthia. Cynthia? I think it's Cynthia Properties.
Anna, can you hear me now?
Yes.
Sorry about that. Yes, I was on previously, but the same thing has been happening. Okay, I just need some questions answered. If a proprietor is earning less than 2.5, was it still necessary to apply for exemption?
Okay, Thomas, less than 2.5 million?
Okay, so if you are earning less than 2.5 million rand, the question is, what should happen to your annual financial statements? They need to be independently reviewed, and you do not need our consent to have them independently reviewed. But the 2.5 million rand has nothing to do with the trust account exemption. The trust account exemption, whether you qualify for it or not, depends on whether you handle trust monies. It is not linked to your revenue. It's not linked at all.
Okay, thank you for that. Now, if we pay penalties, do we still need to provide auditor's report for the year that we are being penalized?
Yes.
Yes, that's correct. Yes.
Okay. Now, if exemption was late for the first year and it was done, let's say 2 months later, okay, why haven't we received our exemption for that year, which is now 23-24?
Are you referring to the trust account exemption?
Trust account exemption.
Oh, okay. So the trust account exemption is not issued annually. So you apply once. Once you get it, then it stays there forever until your circumstances change. So if you have applied for one, you just need to follow up to get your trust account exemption letter, and it's only issued once.
Okay, well, we have followed up with a string of emails to PPRA, and we have heard nothing other than getting penalties all the time. You know, the company's only been registered since 2021. In other words, for 2022, we had to then give an auditor's report, which we didn't. We got penalized. We then asked for exemption, which we still don't have.
If your auditor submitted the winding up audit report.
Sorry?
Has your auditor submitted the winding up audit report?
No, we are presently busy with that.
Well, then you can't get it yet.
Yeah, so we can't give the exemption letter until that winding up audit report has been submitted.
Okay, would it only be for the first year or the second year? Because we don't use our trust account at all.
Okay, it's effective from the date you closed your trust account.
Okay, all right. Yes. That answers my question. Thank you so much, Thomas. I appreciate it.
Okay,
thank you, ma'am. Christopher, please ask. Okay, Christopher, we're not winning. We'll come back to you. Let's give Glory quickly.
It is only available during the
Christopher? Please unmute on your side. We gave you access. I'm not sure if Christopher can hear me. Can Glory hear me?
Yes, I can hear you.
Is this Christoph? Okay, Glory, 1 second. Christopher, please quickly ask your question.
Yeah, I've got, let me just commend you. You have improved from the communication. Thank you.
Thank you, sir.
I've got 2 questions. The first question is, what do you do when the landlord wants the deposit for the tenant? Do you give him the deposit or do you keep the deposit?
Okay, so
okay, the second question is, if now you got people that want, you know, to sell properties, will you be able, am I allowed to employ them? Thank you.
Advocate, do you want to take that one?
Yes, thank you, my lady. First of all, if the landlord wants the deposit, that is governed by the mandate that you have with the landlord. So if you have, when you take an instruction from a landlord to rent out his property, you can only do it on the basis of a contract that you have with him, which can be written or it can be oral. And in terms of that contract with him, you will have decided what your mandate is. In other words, what you have to do, what services do you have to provide. If one of those services in terms of the mandate is that you will keep the deposit in your trust account and you will pay it out along with interest at the end of the lease period to the tenant, then that's what you have to do. If you do not contract for those services with your client and you don't include that as one of the services that you provide, then obviously the trust money goes straight to the landlord. It doesn't come to you. But whether you keep the trust money or whether it goes to the landlord depends on the agreement that you have with the landlord in that regard. And it should also depend on what the tenant's arrangement was. So what did you tell the tenant when you employ or when you signed the lease agreement? If you said to him, in terms of the lease agreement and in terms of your agreement with the mandated agreement, it says that you as the property practitioner will keep the trust account, then you have to keep the trust account and you can't give it to the landlord. If, however, it was part of the mandate or the agreement is silent on it, that the landlord will keep the trust money, then you act in terms of the contract. As far as the sellers are concerned, you are not allowed to employ anybody in the property practitioner industry at all, unless they are registered with us and they have a Fidelity Fund certificate. They have to be registered under your firm, you have to be their principal, and you have to ensure that they comply with all the provisions of the legislation.
Yes. Thank you, Mr. Christopher. Let's go to Glory.
Oh, hi, thank you, Naledi. And Christopher is correct. You are spot on. I love it, my baby. You have improved. I've got 3 questions for Mr. Thomas. Let's start with the first question. PPA 22 of 2020 of 2019.
So that other problem.
Sorry, ma'am. Let me unmute. There's someone who's disturbing your question. Okay, you can continue.
All right. I was saying my questions are directed to Mr. Thomas. The first one is the PPA 22 of 2019. We know that we are granted exemptions on our trust account. So now the question will be, if I'm exempted on the trust account, still the annual accounting reviews of the business account is required. Who is qualified to do that? Can I just take any accountant to do that, or it has to be a CA? And then number 2 question is the current PPA 2022 of 2019. Previously, we know that we're not support. We don't need to have. Okay, I wrote it down. That's the section 112 of 1976, section 32. It says it does not. We don't need the trust account. The property practitioner do not earn. We don't need to earn interest on our. We don't need to earn Okay, Naledi, you have to help me here.
Maybe let's take the first
Okay,
one while you check the.
All right.
Yes, while you check the second question. Mr. Makupu, let's answer her on the first one.
Okay, thank you. So on the first question, I think the question that Glory you have is, who is supposed to do the independent review of your annual financial statements? So my answer is, I'm not sure whether I can, I'm just going to show you the slide where I listed the accounting bodies that can do the independent review.
Okay.
Okay, so I don't know whether I can see on the slides.
Yes, I see. Yes.
Yes. So if you operate a trust account, only a registered auditor can do your independent review. If you do not operate a trust account, it now depends on your public interest score. If it's 100 and above, you can only choose a registered auditor or a chartered accountant. If it is below 100, you can choose any accounting professional who belongs to those accounting bodies listed on that slide.
Oh, I see. I see.
Yes. Yes.
All right. Now, I think I'm answered on that one, sir. I thank you. Thank you, Naledi.
Are you fine with the second one? It's fine. If you remember, please email us, as you typed it. Let's go to, we're closing at 12. So let's take the last two questions, Janine. I gave you access to unmute. Try to unmute on your side.
There we go. Hi, everyone. Can you hear me?
Yes.
Okay, just a question for the PPRA. As a principal, when you're dealing with agents and you've dismissed an agent due to misconduct, and that agent then joins another agency with the FFC, but in that process, he also defames you and goes all over social media and just puts lies on about you that messes up everything for other agents. Does the PPRA protect a principal?
Okay, it's a legal question, but I know Advocate Val is familiar with that. You can come in.
Okay, thank you. It depends a lot on the circumstances. It depends on various things. But what the PPRA has to do is act in terms of its mandate, which is where we are allowed to take action of a disciplinary nature against property practitioners for some sort of non-compliance or some sort of contravention or improper conduct. Then we do so. So if you wanted to, you could submit an application, a complaint against the agent to the legal department using the log a complaint field on the website, and you would then upload all the information and all the proof that you want them to investigate against the agent, and they would then investigate it. It may be that they could investigate the agent for some sort of conduct which is contrary to what is required by a property practitioner, or that he failed to act with the integrity that was required. There could be various other things, but the legal investigator will be in a position to decide whether there is a contravention of the provisions of the Act or Code of Conduct and what they can do about that.
Thanks, Deborah. I'll do that. And yeah, I think you've answered my question. Good.
Luan, Advocate Val, if I can add, we are having a webinar next week, Tuesday, on the Code of Conduct. Luan, please check our social media. The link is there, and our marketing will also share the link today. It's coming out today. Please join. I think it will assist in also understanding the adjudication process that we have in the investigations department. Last question is from Beauty. Please ask your question. Unmute yourself.
Okay, good afternoon. It's almost afternoon. Hi, guys. I just want to ask one question. Is it appropriate that a principal of the estate agents inform the members of the agency that because the majority of the staff speaks Afrikaans and the minority just speaks other languages? Now the office meetings will be conducted in Afrikaans, but people are not denied to attend the meeting. Thank you.
Okay, thank you, ma'am. Advocate, do we take that last one? Ma'am, you're saying that the language that they speak Afrikaans in the office you work in, are you a principal or are you a property practitioner? Which office is this, are they speaking Afrikaans?
Okay, yeah, the office, it was my husband who was working there as an estate agent in the office, and then a principal of the office sent a message to all of them in the group and saying, just know that we have noted that the majority of the staff members of the agency are the African speaking, and we realize that because of that, we have taken a decision that all meetings of the estate agency will be conducted in Afrikaans language. And if you are welcome to attend, but don't expect us to speak in other languages.
Oh, because I sense issues of discrimination. I think we will link you up with Mr. Caton Clarence, you know, because also in the department, there's mediation processes that can assist you if you lodge a complaint, but they would need to look at it if there's jurisdiction. But I'll send you an email. If you have my email, send me. Let's see how we can assist and send us the full story in detail. I'll share my email address now on the chat. So I want to say thank you so much for everyone who joined the webinar today. We appreciate all the questions and all, you know, the queries, the complaints, the compliments. We welcome them. We're going to do it again next week, Tuesday. If we have not answered your questions on the chat, I am going to continue sending out the questions to relevant departments. I saw your email addresses next to your question. They will respond. Thank you so much, everyone. Please, if you are driving, drive safe. Enjoy your lunch. Let's meet again next week. Thank you, Advocate Val. Thank you, Mr. Makubo. I appreciate your time, and thank you, PPRA colleagues, for the support. Thank you. Bye-bye.